Good afternoon, good morning, good evening, everyone. The Caribbean branch of the International Law Association is pleased to host its inaugural event to feature young international lawyers who are engaged in the study and practice of international law. The topic of today's dialogue is the right of self-defense against non-state actors in international law. For this dialogue, the branch is pleased to welcome two very distinguished speakers, Kamille Adair Morgan, who will lead the discussion, and Professor Dire Tladi, who will be our discussant. Kamille Adair Morgan is a qualified attorney at law in Jamaica. She's currently a consultant with the Administrative Tribunal of the Inter-American Development Bank Group. Ms. Adair Morgan recently completed her DPhil in international law at the University of Oxford, and her doctoral research examined the right of states to defend themselves against non-state actor attacks and threats. Dire Tladi is a professor of international law at the University of Pretoria. Among his many roles, he's a member of the United Nations International Law Commission, and he's Special Rapporteur on Peremptory Norms of General International Law, USCOHINS, as well as the South African Research Chair in International Constitutional Law, a Fellow at the Institute for Comparative and International Law in Africa, and an Associate Member of the Institut de Droit International. Professor Tladi is a co-author of the Max Planck Trialogue on Self-Defense Against Non-State Actors. My name is Chantal Anonu. I'm the president of the Caribbean branch of the International Law Association, and I will be serving as the moderator for today's dialogue. Over the next hour or so, Kamille and Dire will explore one of the most contentious issues in international law today, and that is whether a state has the right under international law to use armed force on the territory of another state without its consent in self-defense against a non-state actor. Our discussion today will examine this issue in three parts. First, we will look at the issue of the source of the right of self-defense against non-state actors in international law. Is this right recognized under the United Nations Charter, or is it recognized under customary international law? Secondly, we will explore the question of whether the right of self-defense against non-state actors is really evident in the practice and opinio juris of states. Put simply, is there evidence that states are exercising this right with the belief that they are entitled under international law to do so? And then thirdly, we will look at what are the perspectives of the World Court, the International Court of Justice, on this question of self-defense against non-state actors. Now, for each part of our discussion, Kamille will lead off by presenting her perspectives, and we will have a very, I'm sure, lively engagement with Dire thereafter responding and sharing his perspectives in turn. Now, our viewers are encouraged to use the comment function to pose questions to our speakers, and we will endeavor to raise some of these questions either during the course of the session or at the end of the formal dialogue. So without further ado, I turn over to Kamille to take us through this first issue of what exactly are the sources, what sources of international law recognize the right of self-defense against non-state actors. So Kamille, please, I turn over to you to kick off our discussion on that issue. Welcome.
Thank you so very much, Chantal, for that introduction. And thank you also to the Caribbean branch of the ILA for affording me this platform to share my views on what was my doctoral thesis. I'm also grateful to Professor Dire Tladi for agreeing to engage with me in this way, and I'm sure we'll have a very fruitful and engaging discussion. So the right of self-defense against non-state actors in international law, I think when this topic is thought about, the central question that comes to mind is, does this right exist? Do states have a right to use force extraterritorially without the consent of a territorial state to counter non-state actor threats and attacks? And we've seen that this is a very live question in contemporary legal affairs. So Israel's most recent military campaign in Gaza, for instance, rested on such a right. But more generally, I think this is a matter for the general concern of all states, whether they're states within or outside of regions plagued by terrorism. And that's because the prohibition on the use of force is the cornerstone of the international legal community in which all states exist. And so it's important for states, including states in the Caribbean, to appreciate and participate in shaping the rules that govern the circumstances in which force can be used, and even potentially within their own boundaries. So in terms of this right, it's generally agreed that the trigger for the right of self-defense is an armed attack. So the fundamental normative question is whether this notion of armed attack embraces non-state actor attacks. But before looking at that normative question, I think it's necessary, as you mentioned, Chantal, to look at some theoretical and methodological questions about the nature of this right of self-defense in international law and about its sources. And I think resolving some of those questions will help to, bring together some of the diverging views about whether or not this right exists. So considering first then the nature of this concept of self-defense in international law. For some opponents of a right of self-defense against non-state actors in international law, the immediate objection is that this concept is an interstate one. It's about one state defending itself against another state. And this position is primarily based on a construction of Article 51 of the UN Charter, which recognizes this inherent right of self-defense of states within the broader scheme of the Charter. So what does Article 51 actually mean, and what does it import? And I think it's interesting to note, first of all, that Article 51 itself is neutral as to the source of an armed attack. So it doesn't specify that it has to come from a state. Nevertheless, the argument is made that it is this interstate lens that we must use when we're reading Article 51. And one of the arguments that's made there is that the expansion of the right of self-defense recognized in Article 51 to non-state actor attacks would take that provision outside of the regulatory context created by the Charter, and particularly the interplay of Article 2.4, which is the provision of the Charter that prohibits the threat or use of force by states, and the interplay of that provision with Article 51, which is an exception for states in using force in self-defense. So the regulatory context of the Charter then is of state conduct. It's regulating state conduct. So were this right of self-defense against non-state actors to be admitted, it is argued that Article 51 would be extended to the regulation of non-state actor conduct. But that is actually not the case, because even if a right of self-defense against non-state actors is admitted within the framework of Article 51, it is still the action of the state that is being regulated. It is the state that is prohibited from using force, and it is the state that is able to rely on a right of self-defense. So the acceptance of a right of self-defense, against non-state actors does not present a challenge to the regulatory framework that is set up in the Charter. And a related line of argument that is made here is that the right of self-defense recognized in Article 51 can only be invoked in a response to breaches of Article 2.4, which would be state action, since only states can commit breaches of Article 2.4. So I do not dispute that the prohibition contained in Article 2.4 is an obligation that is imposed only on states, but I do disagree that that is the nature of the relationship between the two provisions. And that's primarily because Article 2.4 and Article 51 do not correspond in scope. Article 2.4 speaks of the threat or use of force, while Article 51 speaks of an armed attack, and that is understood to be a narrower concept than threat or use of force. So not every breach of Article 2.4 amounts to an armed attack within the meaning of Article 151, sorry. And I think it's similar in stating that there's no obvious basis to conclude that every armed attack must also be a breach of Article 2.4. So the provisions do not correspond in that way. I would also argue that to properly understand self-defense as a concept in international law, it is necessary to have a look at historical perspectives, since self-defense as a concept predates the UN Charter. And while it's not possible for the purposes of this discussion to trace the development of the right of self-defense over centuries, I think we can hone in on the early practice of states in the 19th and 20th century in the free war era of international law. And in that particular context, states were free to use force to resort to war without offering a justification. Nevertheless, self-defense existed as a legal concept for states, particularly as a justification for forcible measures taken where there was no condition of war as between the states, so where no war de jure existed between the states. And one of those instances of practice is the oft-cited Caroline incident of 1837, which many of us are probably familiar with in the recesses of our mind. So just to remind us, that was an instance in which Britain had used force against the Caroline, a naval vessel, while it was docked in a US port. And in the diplomatic exchanges between the two states, they noted their agreement on the applicable principles of international law, including the respect for the inviolable character of the territory of a state and the possible exception to which it was liable, self-defense. So Britain categorized its conduct as defensive and also categorized its conduct as perfectly justifiable by the law of nations. And I think there are two things worthy of note here. The first is that Britain was asserting a legal justification rather than a mere political or moral appeal. But more significantly, it was doing so in the context of countering threats and attacks from Canadian insurrectionaries and not from the US itself. So it was making a non-state actor self-defense claim. I would conclude then that both historical perspectives on the concept of self-defense and consideration of the concept within the UN Charter point to the nature of self-defense as a right reserved to states to respond to an act rather than an actor. So turning then to the source of this right of self-defense. And I think this is an important question because it tells us where to look for the answer to the fundamental normative question. And Article 51 of the UN Charter, which I've been mentioning so far, is a good starting point for identifying the source of this right of self-defense. And Article 51 provides that nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. And I think what is clear from the phrasing of this provision and from its reference to an inherent right of self-defense is that it was intended to be declaratory. It's indicative of something not created by the Charter, but pre-existing it. And if this right of self-defense that's recognized in Article 51 is already vested in states and pre-existed the Charter, we'd expect that it would be found in a source of international law. And that source of international law could be no other than customary international law. And this position finds support in the Nicaragua merits judgment of the International Court of Justice of the World Court. So in sum then, Article 51 itself references or recognizes a pre-existing customary law. But not only does Article 51 recognize pre-existing customary law, it is also inextricably linked to customary law as it evolves. So the inherent right of self-defense to which Article 51 refers is not static in meaning. And the first point to note here is that the Charter did not subsume or extinguish this customary right of self-defense in recognizing it. So the fact that it is in treaty terms does not mean that it ceases to exist as a matter of customary international law. And the second point to note is that the nature of customary international law is that it is dynamic. It is susceptible to changes in opinio juris and state practice over time. So by tethering the right of self-defense recognized in Article 51 to this inherent right of self-defense in customary international law, the drafters of the Charter intended an evolutive interpretation of that Charter provision. And I believe it is this interaction between Article 51 as a treaty term and evolving customary international law that allows us to attempt to situate contemporary claims regarding non-state act of self-defense within the rubric of Article 51 of the Charter, notwithstanding the past practice that existed, which ruled out the applicability of Article 51 to such claims. So those would be my initial comments.
Thank you so much, Kamille. And I know Dire has a lot that he would like to respond to. I was very struck by your point that the right of self-defense is the right to respond to an act, not a specific actor. The right of self-defense you have asserted is an inherent one. It's one that predates the Charter, and therefore it is one that Article 51 recognizes, and it could only have been inherent or pre-existing if it existed under customary international law, and therefore the right recognized under the Charter is one which must necessarily evolve over time. And so, Dire, I don't know if you'd like to respond to any of those characterizations of the right of self-defense which Kamille has presented.
Thank you. So I'm getting a message that my bandwidth is low. So a couple of things that you said I've missed, but I think I more or less get the gist. So I'll respond as much as I can. So first of all, thank you again for inviting me. This is it truly is an honor, and I'm really excited to be having this conversation with you, Kamille. I'll start off just by pointing out that I find the question, though, quite interesting. So the question is the source of the right of self-defense against non-state actors, which in a sense assumes that there is such a right. My position, of course, is that there isn't such a right. So there isn't a source for that right. What there is there is a source for the right to self-defense. And so it's that question. And then the question becomes, once we've identified the source, what does that source tell us about the right to use force in self-defense? A couple of things that Kamille said that I absolutely agree with. So I want to start with those things. One, I was struck by the fact that Kamille said Article 51 is neutral as to whether or not a state can use force against non-state actors or not, because it simply says armed attack. Most proponents of the argument that Kamille is putting forward don't adopt that position. They adopt a slightly different position, right? So the position that they adopt is it's not neutral. It says an armed attack. It doesn't say an armed attack from a state, which means that, of course, a state can use force against non-state actors. Whereas Kamille's argument is a lot more nuanced and I think therefore a lot more sophisticated. It's that Article 51, the words in Article 51 themselves don't tell us. I would nuance that even further. I wouldn't say that Article 51 doesn't tell us. I would simply say that the language, the ordinary meaning of the words don't tell us much. But Article 51 itself, through the rules of interpretation, and I'm sure we'll talk about that as we proceed, tells us a lot, right? So if one thinks about the rules of interpretation and one applies the rules of interpretation, then one will come to the conclusion, I think, that Article 51, in fact, does tell us. Now, Kamille spent a lot of, actually one more point I want to mention before I go through the customary international law points that Kamille made. So Kamille also made the point about terrorism, that really all of this is about terrorism, right? It's a response to terrorism. Those states that believe they have this right, because they need to fight terrorism. That point, I think, has to be borne in mind. My perspective is that the issue of terrorism, as real as it is, requires a response from a lawmaking perspective and not a use of force perspective, right? It's a lawmaking requirement, and we have seen that the Security Council has in fact taken action. Now, whether that action is effective or not is something we can talk about, and whether the effectiveness or lack thereof somehow leads to the expansion of the right, that's something else we can talk about. But it's important to understand that for me, what that calls for is it calls for legislative conduct. So it's criminal responses and criminal law responses rather than, I think, the use of force responses. So I'd make that point also. A further point on which I very strongly agree with Kamille is that custom international law is dynamic. I think, though, that the effect of this disagreement leads us to different places. So that's one of the reasons why it's not the only reason, but one of the reasons why I completely discount, for the purposes of this discussion and for the purposes of identifying the rules of law, the Caroline incident. I think reliance on the Caroline incident for whatever purpose in this discussion is completely, normally I say it's anachronistic, but I think as a matter of law, it really doesn't take us very far. A couple of points to mention. First of all, as Kamille rightly said, at the time of the Caroline incident, what was it, in 1837, so around 1837, the use of force was not prohibited. And if the use of force is not prohibited, so I disagree with Kamille. It's not clear to me that a state would need to justify, as a matter of law, its conduct. I read the exchange between the United States and the United Kingdom as two friendly nations talking about and justifying their actions from a political perspective. In that exchange, there is a point where the Secretary of the Foreign and Commonwealth Office says, you cannot expect the United Kingdom to attack such a friendly and yet powerful nation as the United States. It does seem to me that exchange was a lot more about politics, morality, and political high ground rather than making legal arguments about what is or what is not permissible. Secondly, even if that was a point establishing a rule of customary international law, because customary international law, it's dynamic, I think it's rather problematic to sort of look back and to base arguments on customary international law based on that incident. The main problem, though, with the pre-existing customary international law argument is those that make the argument never show us what the practice is that they're dependent on. They just simply say, well, Article 51 speaks about this inherent right. Inherent right, you can look at Nicaragua, it recognizes that this right exists in customary international law. That's enough. But that's not enough as a matter of law, right? So as a matter of law, you still need to say, well, here's the practice. What practice is there prior to 1951? So prior to 1945, 1951, so Article 51. So prior to Article 51 of the Charter, of circumstances in which the law prohibited the use of force, in which a state used force against non-state actors in the territory of another without any attribution. Nobody ever presents such arguments, right? So that's part of the problem. And Caroline is not, because, by the way, even if discounting everything I've said about Caroline, even if somehow someone could say, well, Caroline has survived everything that has happened in history from 1837 to 2021, it's still not clear to me that two states, no matter how powerful they are, conduct one incident between two states is sufficient to establish a rule of custom international law. That just completely blows out the water this idea of a widespread and general practice, right? So that's part of my difficulty. But more than that, because custom international law is dynamic, it's hard to deny that the charter framework would have somehow affected whatever rule may have pre-existed. I mean, I certainly agree with you that to look at the rule on the use of force, including whether or not the use of force allows self-defense against non-state actors, custom international law is important. But I also think that Article 51 is important. I think Article 51 and custom international law, in a sense, because of a number of methodological rules relating to how treaties influence custom international law and custom international law influence treaties, they operate in sync in such a way that regardless of which one you analyze, ultimately, I think you come to the same outcome. So even if you analyze Article 51, and by the way, I do think that Article 51 is a self-standing rule, right? I think it is a self-standing rule. It's a self-standing rule that is not intended to affect the existing custom international law, but the effect of that, because of Article 38(1)(c) of the Statute of the International Court of Justice, which requires that treaties Article 31(3)(c) of the Vienna Convention on the Law of Treaties, which require that treaties be interpreted consistent with existing principles of international law. That sort of connection between the sources helps us ensure that the rules of custom international law and Article 51, in fact, are consistent. So ultimately, I think that both of those sources lead to the same conclusion, and that same conclusion is that international law does not permit the use of force against non-state actors, save where there is some kind of attribution. Obviously, so that's a big exception. If there's some kind of attribution, then the use of force is in fact not against the non-state actors, but it is against the state itself, because the conduct of the non-state actors can be attributed to the state. What have I left out in responding? Oh yes, you said something about the relationship between Article 2.4 and Article 51. I think that's absolutely critical, and that is indeed my position is that Article 51 is an exception to Article 2.4, and it wouldn't make sense for the scope not to be the same. So I'll leave it there. There are a couple of other things, but I'm sure they'll come up as this conversation continues.
And what a start to this conversation. So right off the bat, there are some interesting points, and I'm sure Kamille is going to want to respond to before we move to our next segment. I just wanted to note that both Kamille and Dire raised this issue of what does state practice reveal, and we're certainly going to come to that in the second part of our discussion. So leaving that point aside, meaning what does state practice reveal, Kamille, I don't know if there's anything that you would want to say at this stage. I found very interesting, and I gather that a comment came in that picked up on the point that Dire raised, that the appropriate response is a lawmaking response, not a response involving the use of force. But Kamille, please, I'm ceding the floor to you now to see if you'd like to respond to anything Dire said before we move on to the next segment.
Right, and I wholeheartedly agree with that the primary paradigm for dealing with non-state actor threats has to be a lawmaking one, has to be a domestic law enforcement paradigm. And I think this is directly relevant, not so much to the question of whether this right of self-defense against non-state actors exists, but to whether or not it is exercisable in a particular circumstance. So domestic law enforcement has to factor in terms of assessing whether there's a necessary use of force here. So the fact that a right of self-defense against non-state actors exists doesn't mean that states are free to invoke that right in all circumstances where they're attacked by states. The primary paradigm has to be a law enforcement one. And so it is expected that uses of force in self-defense against non-state actors will be particularly exceptional. Whether or not that has been the case in practice is open to debate, but I think fundamentally that is what the rules indicate, that this has to be a particularly exceptional use of force. So that's what I'd say on that point. And just very briefly on the Caroline point, I agree as well that the arguments that say, let's look to 1837, there was a pre-existing right of self-defense against non-state actors. And so in recognizing this pre-existing custom, the Charter recognizes the Caroline and what was created there. I think those arguments are faulty. But I think the Caroline incident is important. And I think Dire and I disagree about the context there. As I said, I do believe that Britain was relying on legal argumentation, particularly in the context of a circumstance short of war. There was no war as between them, and therefore the use of force would not have otherwise been justifiable outside of that self-defense, arguably necessity context. But I think the Caroline incident is important for showing us that even in its earliest conceptualization, this non-state actor concept of self-defense was not problematic in international law. So I think it's more so that perspective as distinct from it carries over into the Charter era as customary international law.
If I may.
Please, Dire.
So there's a nuance that Kamille keeps pointing to, I would say pre-1920s, I adopt the position that states were free to use force. Kamille, you seem to be saying states were free to use force in the context of war, meaning that if there wasn't a war, then states were not entitled to use force. I mean, if that's the point that you're making, then absolutely you're right that the Caroline might be relevant for sort of shedding light on that. But I don't think that position is correct. I don't think that position is correct. I think states were free to use force full stop prior to 1928. In fact, even in 1928, it was really a multilateral, almost global prohibition on the use of force. But it's clear to me that prior to that, states were entitled to resort to force, and not just in the context of war. There is a slight difference, and I would be very interested to hear what your perspective is.
Kamille?
Right. So that is, in fact, my perspective, that in terms of the practice of that period, states were free to engage in war as between themselves without offering a legal justification. But where there is use of force as against the state, where no state of war existed between the two states, which I think is very clear from the correspondence between Britain and the US. And I think the point that you mentioned as well, where Britain said, they're friendly states in this context, but seeking to offer justification for that use of force in self-defense. So I think the two situations were treated as fundamentally distinct as a matter of the law of nations, which Britain specifically referred to and which both states agreed on, that they were looking at the law of nations and the principles that governed how states related in that era. So I think the two situations are fundamentally distinct, and therefore Caroline can offer us some guidance on how to conceptualize self-defense even as it exists today.
Yeah. So let me just say a couple of things about why. I mean, I agree with you that if you read the exchange between the United Kingdom and the United States, there is, and I don't have it in front of me, but there is a passage or a line that seems to suggest that the United Kingdom is relying on legal principles. But I think that they were not relying on legal principles, or that it was not relying on principles. But the big point I do want to make, though, is that if you look at the Kellogg-Briand Pact of 1928, which is the first sort of global attempt at prohibiting the use of force, it doesn't suggest that it's only talking about the use of force in the context of war. In the context of a war that is taking place. Yes, it speaks about war. It says states renounce, so that idea of renunciation of something that you already have, renouncing a right you have. States renounce the right to resort to war. So it's in that context that war is used, but it's a right to resort to war, which means it's a right to go to war, a right to use force in the context outside of war, so before war has started, right? So the first use of force is, in a sense, the right to go to war. And that's a renunciation of that. So prior to 1928, states were free to go to war, to use force, and they didn't have to justify that. And it's also clear from the Kellogg-Briand Pact that it's the right to use force as an instrument of national policy, not a right to use force in the context of war, right? And so the Kellogg-Briand Pact talks about as an instrument of national policy. And if the right to use force or the right to go to war was permitted under international law, then it's not clear to me why you would need to legally justify. You need to legally justify something if it's prohibited by law. If it's not prohibited by law, you don't have to legally justify it. You can still justify it, but you don't have to legally justify it. So yeah, I think that prior to 1928, states could go to war. States could use force even outside the context of war, and because of that, the Caroline incident and the exchange has, and this is stating it very kindly for the United Kingdom and the United States, has zero relevance for me to the discussion. It really doesn't help one way or the other. It's an exchange between two states. If they thought that they were stating the rules of law, okay, they were wrong. If they thought that, I don't even think they were thinking that, but anyway,
but
I wasn't there.
I think this exchange leads us very nicely to the second segment of our discussion. And that is this question of, what does state practice reveal about this issue of the ability of states under international law to defend themselves against attacks by non-state actors. We've kind of touched on it. There have been several references to state practice in the earlier segment. But Kamille, I really wanted to allow you now to share your perspectives on this issue. What did your research reveal about state practice on this issue, and whether states were actually, whether there was state practice supported by opinio juris in this area? Please, Kamille.
Right. So I think the point on which Dire and I agree, and from which we can therefore move forward, is that the evolving state practice is more significant. The state practice that has happened since 1945. But before delving into looking at what has happened in the practice of states since that time, I think it is important for me to just very briefly set out what my methodological approach is to the assessment of customary international law. So the first thing to note is that whether non-state actor attacks are armed attacks within the meaning of customary international law, and therefore Article 51, is a question of the actual practice and opinio juris of states. In other words, is there a general practice accepted as law? And this two-element approach is very widely accepted. Secondly, state practice must be general. It must be sufficiently widespread and representative, as well as consistent. This means that the support of all states is not required, but it equally means that a customary norm cannot be asserted where it is not supported by a significant portion of the international community as a whole. Thirdly, in terms of determining this generality of practice, the relevant practice is not limited to actual extraterritorial uses of force countering non-state actor attacks. And we will see that less than 30 states actually have invoked a right of self-defense against non-state actors. But the practice also embraces verbal acts. And I argue as well that inaction or silence is also relevant to determining the extensiveness of the practice in this area. And considering the exceptional nature of the right of self-defense, the right that is being asserted, it is to be expected that the evidence will not be found principally in uses of force by states. So it's not just about the claims that are being made, it's equally about the responses to those claims. And finally, then, on the matter of silence and inaction, it is not asserted, or I'm not asserting, that silence automatically or invariably counts in favor of a customary norm being asserted. It may count as evidence of a general practice in certain circumstances. And those circumstances, I argue, are where a state is in, the state that is silent or has not acted is in a position to so act, to react, and where the circumstances call for some reaction. And I argue specifically that the circumstances call for a reaction not only where a state is directly and unfavorably affected by an instance of practice, but also where that instance of practice has precedential value. So where it has the ability to initiate or confirm a new dispensation or a substantial shift in customary legal practice. So with those in mind, then, examining the practice itself. And the events of 9/11 are easy to point to and are often pointed to as a starting point. And some would even say that they represent a Grosjean moment, a moment of instant or accelerated formation of customary international law. My position, however, is that the determination must step back. We have to factor pre-9/11 instances of practice where self-defense was invoked in circumstances of attacks perpetrated by non-state actors. And we see several of those in the post-charter but pre-9/11 period of international law. And what the practice of that period reveals to us is that there were shifts in the practice. There were shifts in the claims that were made by states, and there were also shifts in the responses of the international community to those claims. So looking first then at shifting claims, in the early charter era, Israel most notably was involved in cross-border military attacks against irregular forces in neighboring countries, and a right of self-defense was expressly relied upon by Israel. But what is important to note about those early claims is that Israel asserted a right of self-defense as against the territorial state itself. So in 1968, for instance, when it carried out an extensive campaign in Lebanon in response to attacks by the Palestinian Liberation Front, who Israel alleged was based in Beirut, Israel asserted that the government of Lebanon bore direct responsibilities, not vicarious ones, for the actions carried out. So we see that sort of attribution of the non-state actor attacks to the state. And those claims were, of course, rejected by states on the basis that Lebanon bore no responsibility and therefore self-defense could not arise in the circumstances. But we do see a shift in the claim as made by Israel in 1978. And in that year, following a terrorist attack on its territory, so a very similar attack, also from terrorists based in Lebanon, Israel on this occasion adjusted the focus of its legal justification. There was no allegation of Lebanese responsibility. Instead, Israel asserted that it was acting against non-state elements as present in Lebanon, while maintaining its support for the national sovereignty and territorial integrity of Lebanon. So that is a very distinct non-state actor self-defense claim. And Israel continued to make such claims into the 1980s and 1990s, not only with respect to non-state actors in Lebanon, but also in Tunisia. And during this period also, we see other states joining Israel in making these claims. So we see Iran asserting such a right to counter non-state groups in Iraq and Afghanistan. We also see Tajikistan making such claims as against non-state elements in Afghanistan. Turkey also relied on self-defense, Kurdish rebels in Iraq, although admittedly, Turkey did not expressly invoke Article 51 of the Charter itself. And we also saw such a claim being made by the US in 1998 with respect to its use of force in Afghanistan and Sudan following terrorist attacks on its embassies overseas. And what's similar about these claims and the refashioned claim as made by Israel, is that all these states asserted that they were acting against non-state actors, targeting non-state actors, while maintaining respect for the territorial integrity and sovereignty of these territorial states. So we're seeing a shift in claims, but we also saw a shift in responses. So Israel's 1978 refashioned claim as against non-state actors was equally rejected by states when those matters were considered, particularly in the UN Security Council. In fact, in one of those considerations, states said, what Israel is arguing is a bold misinterpretation of the Charter. In 1985, however, we saw that the US began advancing a position against the tide of condemnation, and it explicitly recognized Israel's claim of a right of self-defense against non-state actors. And we see progressively more positive responses of the international community since that time. So we see in the 1990s that there was no condemnation of Iran's action or of Tajikistan's action, for instance. And we also saw that there were general expressions of support and understanding for the US's action in Afghanistan and Sudan. And it is this practice that brings us to the events of 9/11. So while I reject that 9/11 is this novel Grosjean moment, I think it's significant in the chronology because it evidences a concerted international legal response to a very distinct non-state actor self-defense claim. So the US and the UK made a claim of non-state actor self-defense, to which the Security Council unanimously responded in its resolution 1368 and 1373, recognizing this right of self-defense. There was the invocation of various collective defense machinery in response to the US claim. So the OAS invoked its collective defense machinery, as did NATO for the very first time, invoke its collective defense machinery. And what's significant to note about that is that there was an indication that it was being invoked in circumstances that were not initially conceived, that is, in the non-state actor context. There was also general support for the US and its allies' action by different regional blocs of states. So the EU gave its support, as well as Arab states. And we also saw Article 51 communications being sent to the UN Security Council, claiming a right of collective self-defense within the meaning of Article 51. So the 9/11 practice is simply the continuation and consolidation of decades of converging practice. And against this backdrop, the pre-9/11 practice providing that backdrop, the overwhelming positive legal response of the international community signals that a shift in international legal thinking on the issue had occurred by that time. And of course, the momentousness of 9/11 and the response would, I think, go to the argument that the silence of other states would signal an acceptance of that legal argumentation. But beyond 9/11, though, I think the classification of non-state actor attacks as armed attacks has continued to be affirmed in the post-9/11 practice of states. So such claims have increased in frequency, and significantly, they have been made by states of varying geographical classification, so beyond the usual suspects. And those claims provide evidence of a more general and representative practice than is sometimes acknowledged. So we've seen claims being made by states in the Middle East. For instance, Bahrain, Qatar, Saudi Arabia, UAE, and Kuwait with respect to uses of force in Yemen. We've seen such claims being made by African states, by Liberia, by Ethiopia, and also most recently by Egypt with respect to its use of force in Libya. We've seen such claims, of course, by European states, and Russia has done so, for instance, with respect to its use of force against Chechen terrorists in Georgia. We've seen Colombia, as a South American state, make such a claim, re the FARC in Ecuador. And finally, I think the coalition action against ISIS in Syria is very indicative, because there we see states from various regional blocs supporting the action that is being taken against ISIS, a non-state actor on the territory of Syria. So the final thing I'll say is that this practice is not universal, and I accept that. So states like Mexico and Brazil have been very consistent and vociferous in recent years in their opposition of this right of self-defense against non-state actors. And in the informal meeting of the Security Council that took place in February, as you mentioned, Chantal, Sri Lanka expressly rejected these rights, and arguably also China. But the requirement, as I stated before, is not for a universal practice, it's for a general one. And I think there is a sufficient degree of uniformity and representativeness in the practice regarding the classification of non-state actor attacks as armed attacks within the meaning of customary international law to satisfy this requirement of a general practice accepted as law.
Thank you very much for Kamille, for very clearly setting out your perspective on this issue, setting out your understanding of what the requirements for establishment of customary international law actually are, making it very clear that your conclusion is not based on a finding of universality in the practice, making it clear that you've identified that there are countries which have very consistently not recognized that right. Also very clearly pointing out that you don't regard this to be practice that only started with the events of 9/11, but that predated it. And I think you specifically mentioned a shift that you observed in the practice from around 1978, where there was no attempt to attribute the actions of non-state actors to a state. Dire, a lot was said. I saw you taking notes, and I know you probably want to respond. I have an inkling that you may have a few thoughts you want to share at this stage. So please, what are your thoughts on this question of what state practice reveals?
So first of all, I really enjoyed that, Kamille, and I look forward to reading your doctoral thesis. I do have a lot to say. I hope I can remember all of it. I normally have difficulty reading my own handwriting, but I hope I can remember all of it and respond. I'll start off with the methodological points, because I fully agree with you. Well, not fully, but I agree with you more so than I normally agree with people who advance this position. I think that your description of the methodological framework is apt, and I fully agree with it, except for one point. The one point on the methodological framework on which I disagree with is your description of when silence ought to be given legal significance, right? So I think you're absolutely correct in your description of, well, it is if you're in a position to act and the circumstances call for some reaction. But it's your description of when the circumstances call for reaction that caused me to pause, and that's an understatement, because you're basically suggesting if a particular act could have precedential value, then the circumstances call for a state to react. And I think that would be placing undue burden on many states, because states will not know when an act is likely to have precedential value until after the fact, right? So we're discussing all of these things. I don't think that if you had asked state representatives in 1978 about the examples you give on the use of force in Israel versus Lebanon, would this have precedential effect? They would know that, oh, by the way, in 2021, Kamille is going to make this argument using this, right? There are some exceptions, of course, and I'll come to the one exception where you can say, well, this was obvious. This obviously was going to have precedential effect. I think, in fact, there are two examples, actually. I mean, the two examples are 9/11 and the Syria use of force. So those are two examples in which one can say, yeah, here the circumstances call for reaction. This is a big enough thing. And I'll come back to those, but I do want to sort of address the pre-9/11 examples first. So as far as methodology is concerned, absolutely, except for that one point. I think what we mean by when circumstances call for reaction, I think that we have a slightly different view of, so when that might be. I also think that 9/11 is actually critical, but for a very different reason than most, right? So I think 9/11 is critical because, as you say, many people say, well, it's the Grosjean moment, right? It's the time when the law changed. In the separate and dissenting opinions or in International Court of Justice, which I know we're coming to, the judges point to 9/11. So we know that 9/11 is critical for those that adopt the position that you adopt. But that's interesting because that tells me that there is an acceptance that initially you could not use force against non-state actors in the territory. So there has been an evolution. In fact, now that I think about it, even in the way that you describe it, although you don't use 9/11 as a definitive moment, there is an assumption, an almost imperceptible acceptance that there has been a shift, right? That the law initially didn't permit, hence Israel had to use attribution because even Israel accepted that there had to be attribution. The US later, you say, it was only in, I think you said 1980s that the US began to now also accept. So even in your own description, it seems to suggest that the law initially didn't permit. And that's an important point. One, it's an important point because it discounts the point you were making earlier in our first segment about, well, the inherent right has always been, right? Because it accepts that, no, that it hasn't always been. There has been a shift. I mean, that seems to be the argument. The argument is there has been a shift. So that's the first point. But the second and more important point from a methodological perspective is that, remember, the rules of custom international. So there is a rule of custom international law. It does not permit. Now you are arguing that there is a shift, which means that you must show the widespread and general practice. So it's not enough to show a little bit of practice here and there. It's not enough to show that a couple of states accept it as law. You need to show the general practice. And you also need to show not just that this practice was undertaken by those that undertake the act with a certain acceptance of law, but even those on which you are imputing the silence, right? So you're saying silence can mean acquiescence, silence can mean acceptance. Even those, you need to show their opinions, right? So I don't know, I guess Malawi hasn't said anything. You also need to show that Malawi accepts that even though you can say, well, it is acquiesced to this practice, that's not enough. There is still an onus on you to show that they also accept this widespread opinion use. Remember, right? So the point of all of this rambling is that the onus, this argument, this point about a shift, places the onus on those that are making an argument for the shift. It applies also to custom international law. Now, let me get to the examples of practice. Of course, there are many examples of practice. I mean, the examples of practice that you didn't mention. I can, for example, tell you that South Africa used to go into neighboring countries and it used to say self-defense, right? And consistently states said, you can't do that. You can't exercise self-defense against a state that has not, right? So absolutely there are examples. Fortunately, on some of them, there were Security Council debates, right? So in the Security Council debate, one finds, I mean, sort of the 2006, for example, Lebanon, Israeli incursion into Lebanon, the debates are clear. I mean, there were some states that were referring to the conduct of Israel as an act of aggression, right? So it was clearly no general acceptance. There was certainly some states that accepted it, but no general acceptance. Let me just look at some of the other examples that you gave. You also referred to the use of force by Colombia Ecuador, there was, by the way, a ministerial decision by the Organization of American States denouncing that act. Right? So not just one state, it's a whole organization denouncing the act, again, specifically on the basis that you can't use force against non-state actors. The incursion of Turkey into northern Iraq. Many states expressed sympathy for Turkey, but still said these unlawful acts that you've had to face from the Kurdistan Workers' Party cannot be a justification. The acts of force by the United States in Sudan and Afghanistan prior to 9/11, there were responses, there were negative responses. Again, remember, once you've made the point that there has been a shift, my position is as long as you have states responding negatively, that prevents the establishment of a rule of custom international law, because you already have a rule of custom international law. It's not just the creation of a rule, it's essentially the overturning of an existing rule. That makes it even more difficult, right? So when states are constantly responding and objecting to the use of force, that undermines the possibility of the establishment, that undermines the possibility of a widespread and general practice. It certainly undermines the possibility of the establishment of an opinio juris that is general. Remember also, and this is why there are many examples of practice. There are many examples of practice in different regions, that sometimes politics override law, right? And so you might find a state that is opposed to this one day acting in that way. And I think that goes to the opinio juris. So a lot of the states that you mentioned, I guess this is post 9/11, so we'll come back to those, of states which in different contexts, in different groupings, have said this is not permissible. So as soon as you mention an unaligned state, right, I'll say, well, the unaligned has a position which is fairly consistent, all right? Which is fairly consistent, that the rules on the use of force cannot be used in response to terrorism. That the use of force in Article 2.4 in the Charter has to be interpreted restrictively, and can't be, that's 130 what states, 133, 134, I don't know how many states, but it's a lot of states, right? It's a lot of states. So that can't be forgotten. Brings me now to 9/11. So 9/11 is not a Grotian moment for many reasons. One reason that I normally put forward why 9/11 is not a Grotian moment is that it's not clear to me that the conduct of the United States in Afghanistan was without attribution, at least from the perspective of the United States. Now, whether the level of attribution is right or wrong, that's a different matter. But if you read, because I didn't listen, I read, the speeches of George W. Bush in that period, there was a lot of attribution on the Taliban, the government of Afghanistan at the time, right? So I'm not, and that's the one example in which there was practically no response. So I tried to find negative responses to the US use of force in Afghanistan. I could find none. So they're absolutely right. There's absolutely no negative response. But it's not clear to me that that example itself is actually an example of the kind of situation that we're talking about. I don't think, and it's very interesting when people speak, I don't think that resolutions 1368 and 1373 say what you say they say. They don't say we recognize the right of the United States to use force against Al-Qaeda. They don't say that. There's a preambular provision recognizing the inherent right to use force. That's it. It says nothing about the situation. If you read preambular provisions in UN Security Council resolutions, they say many things that may or may not be directly applicable to that situation. All they say is recognizing the inherent right of self-defense. It doesn't say recognizing the inherent right to use force in self-defense against non-state actors. It doesn't say recognizing the inherent right. It's, to use your words from earlier, it is completely neutral, very much like Article 51. Right? So I don't place much stock in those. For me, the really impressive, almost convincing examples are almost convincing, Chantel, are the Syria use of force, the cases of the use of force, because there's just simply so many. And as you rightly say, Kamille, there's so many from so many different regions. But there have been negative responses. And again, bear in mind, once you say that there has been an evolution, then it's a big hurdle to overturn an existing rule of custom international law. And I think because of that, as impressive as the number of cases are, it's certainly difficult to make the argument that it has been sufficient to use force. So I will make this one other point. We have been looking at this solely from the perspective of custom international law, because that's Kamille's favorite ground. I mean, I think treaty law is equally important. So, but even under custom international law, those states that are using force in Syria are all advancing very different reasons. And because they're advancing very different reasons, it's again difficult for me to think, well, what opinio juris is this? So remember, opinio juris is you're accepting something as law. It's not enough to say, I'm accepting that I can use force. You have to be able, I think you have to be able to say, I'm accepting that there's a legal rule that permits me to use force, and the legal rule is this, right? So it's the acceptance of the legal rule, but they all have different legal rules in mind, right? So just now think, so Germany's legal rule is that the territory in which they're using force is no longer in the control of Syria. Belgium is saying, well, this is completely exceptional. This shouldn't be done again. So essentially what they're saying is this has no precedent at all, right? So that's not even a legal rule. The US and Canada and others are using the able and willing test, which I guess is the argument that you are supporting. So there are all these different rules that are being put forward. It's hard for me to see how you can say there's an opinio juris, right? So from a treaty perspective, I would say it's hard to say it's hard for me to see how one could say there's an agreement as to the interpretation of Article 51, which would be required to be able to make the point that that practice has some legal value. And I'll stop there.
Wow. So again, this exchange is showing the various aspects of this debate on which many scholars are not agreed. And what I found very interesting in the perspectives that were put forward by both Kamille and Dire is that you have very different interpretations of similar instances of practice. But Dire, what you said quite clearly is that if the argument is that there has been a shift, then I understood you to be pretty much saying the evidentiary burden is higher, in that if there has been a shift, one would expect that there wouldn't be many negative responses, if I understood you correctly, in order to support the existence of the requisite state practice. I'm watching the time. I know that both of you could engage in this for quite some time. I want us to move on to our final segment, which really looks at this question of what has the International Court of Justice said on this issue? What can we glean from decisions of the International Court of Justice on this important question? We've looked at the interaction between customary international law and the UN Charter. We've looked at what can we discern from state practice. What is it that we can discern on this issue from the International Court of Justice? So Kamille, I'm going to hand over to you to share your perspectives on this question before we also invite Dire to share his. Kamille, please.
Thank you. So if I may, just one last thing I will say on the practice. So I accept what Dire has said about the negative responses, but I think we need to look at why they were negative. So not just that they were negative, but why were they negative? So in a lot of these situations, it was beyond the preliminary justification to questions of the disproportionality of action, which is also a basis on which use of force can be illegal. In Colombia's case, for instance, there was also the fact that the consent of the state was not first sought. which I argue is actually relevant to assessing whether the use of force was necessary. So in short then, not just looking at negative responses, but looking at why the responses were negative. And I think that can help us to clear up a lot of, is there really support for that core right of self-defense against non-state actors? So turning to the jurisprudence of the ICJ then, so judicial decisions are really important in this context because they're a secondary source of international law which help us with identifying what the rules actually are. And this is an area in which the ICJ arguably has said a lot. I would argue not as much as could have been said, but the ICJ has dealt with this question of self-defense where uses of force have been perpetrated by non-state actors. So it's necessary for us to look at what they've said. And the first such consideration by the court was in the Nicaragua case of 1986, which all law students who've done any amount of international law are familiar with. But again, just to refresh your memories a little bit, in that case, the US claimed that it was acting in the collective defense of El Salvador in response to attacks carried out by the Salvadorian insurgency, which the US alleged was armed and otherwise supported by Nicaragua. So the court had to consider whether El Salvador was the object of an armed attack, substantiating the US's claim of collective self-defense. And the famous statement of the court there is that it can be agreed that armed attacks must be understood as including not only actions by regular armed forces, but also the sending by or on behalf of a state of non-state elements who carry out attacks against states or the state's substantial involvement therein. And this statement, or the Nicaragua test as it's often referred to, was recognized by the court as being reflective of customary international law at that time in 1986. And again, as reiterated in its jurisprudence as recently as 2005, as representing customary international law. So from the court's perspective, this sending by or on behalf of test continues to reflect customary international law. And what the court appears to be saying in that test is that a non-state actor attack amounts to an armed attack where it is in some way attributable to a state. And the contemporary practice, which I discussed earlier, appears to be in conflict with what the court has said in the Nicaragua case, because in those instances, as I've argued, attribution was not at all central to the claim of self-defense. So where does that leave us? If I assert a right of self-defense against non-state actors, am I also asserting that Nicaragua is no longer good law? And I think that would appear to be the result, but I argue that it's possible to reconcile what the court has said in the Nicaragua case and what it has reiterated in its subsequent jurisprudence, and this right of self-defense recognized in the contemporary practice of states. And that is because I think the correct interpretation to be given to the Nicaragua test is not that a use of force by a non-state actor is an armed attack only when it is sent, the non-state actor is sent by or on behalf of a state, but that the correct interpretation of that particular test is that in the circumstances of a non-state actor attack, there is an armed attack by the state triggering a right of self-defense against the state when the non-state actor is sent by or on behalf of the state. So I think the contemporary state practice and what the court had in its contemplation were just two different things. And if we look at what the court said about the scope of its investigation, the court said it was looking to see what support Nicaragua had given to the Salvadorian insurgency and whether that support amounted to an armed attack. So the court was contemplating an interstate use of force. It did not have in its contemplation whether actions by non-state actors themselves, regardless of state support, constitute an armed attack triggering a right of self-defense otherwise. So I think it's possible to reconcile them in that way, but more importantly then, the continued relevance of Nicaragua, the continued reiteration of the Nicaragua test does not undermine the conclusion that this right of self-defense against non-state actors exists. I think it's a little more complicated when we look at the post 9/11 jurisprudence of the court, and particularly the Wall advisory opinion and the armed activities case, which were handed down in 2004 and 2005, respectively. And those cases also considered self-defense in the context of uses of force by non-state actors. Starting with the Wall advisory opinion, I think there the court was directly called upon to declare that self-defense was applicable in a non-state actor context. And that's because Israel argued that the wall that was being constructed was a defensive measure as against terrorism, consistent with Article 51 of the UN Charter, and specifically UN Security Council Resolutions 1368 and 1373. And the court's response there was quite abrupt, and I would argue very vague, because what the court did was it cited Article 51 of the UN Charter verbatim, and then it said, this provision thus recognizes the existence of an inherent right of self-defense when one state is attacked by another state. But as mentioned before, Article 51 doesn't state that that is the case. So I think the basis of the court's conclusion was not laid out by the court. And to my mind, that makes the jurisprudence of the court, particularly in this case, open to question. And beyond rejecting that Security Council resolutions 1368 and 1373 were applicable, on the basis that the court said Israel was speaking of a use of force in territory that it had occupied, whereas resolutions 1368 and 1373 were about attacks against the US, not in territory occupied by the US, and therefore we can distinguish those resolutions and they're not applicable here. Beyond that, the court did not actually engage with the practice. And so I think its pronouncement of its interstate conception of use of force is not very helpful to our investigation. And I think the same can be said of its decision in the armed activities case, where Uganda claimed that it had suffered cross-border attacks from insurgents in the DRC. And what Uganda specifically argued was the activities of these insurgents were coordinated by and subject to the command and control of the Congolese government. So in rejecting that particular claim, the court said, we don't see any evidence of DRC involvement in the actions of these insurgents. And accordingly, there's no need for us to respond to the contentions about whether contemporary international law provides for a right of self-defense against attacks by irregular forces. So the court seems to be saying there, because DRC was not at all involved, we don't need to look at this question of self-defense against non-state actors. In my view, the court wasn't necessarily addressing its mind to non-state actor self-defense, because as I said, I think the argument that Uganda was making was an interstate one. But even if the court was rejecting this concept of non-state actor self-defense, by its own admission, it did not engage with a practice. It stated as evident that because there was no state involvement, there is no self-defense, and therefore we don't need to look at these questions. So my conclusion then is that the jurisprudence of the ICJ, though it signals or it's in favor of an interstate conception of self-defense, it actually isn't very helpful for the determination because the court has not engaged with the practice.
Thank you very much for sharing your perspectives on that issue, Kamille. Very clearly laying out your rationale as to why you don't regard the court's jurisprudence on this specific issue of whether a right to self-defense against non-state actors exists. And Dire, I wonder if this might be one of the three areas where we see some concurrence. let me see
I
what,
think
okay.
I think there's a lot of concurrence here, not necessarily with the outcome, but certainly in terms of the reasoning. So let me just say I couldn't resist saying something about the rejection of practice. It is true that some states objecting to practice, and some entities, because you also have the SG and so on, do link the rejection to necessity and proportionality, but only some. Many of them just simply say, well, you shouldn't violate the territorial integrity. And for me, that sounds like a broader rejection. So that's this point. The second point I would make about that, though, is that you've said many things, and I've rejected to those things that I can, but I haven't responded to everything that you've said. And I don't think you've responded to everything that I've said. And I don't think that means that you agree with everything else that you haven't responded to. It's just that's what, so for me, the point is that if there's a rejection of that practice, it doesn't matter what the reason is, it just simply undermines it, unless the rejection is, we accept that it is possible theoretically to use force against non-state actors, but in this instance, it's not acceptable. And those states don't say that. They just, so even those states that are rejecting it on the basis of necessity and proportionality don't make that leap. So the point of rejection is we discount that practice, sort of wipe it off the floor. But on your point about the ICJ, I mean, absolutely, I think that the ICJ hasn't engaged with the practice. And I think that the ICJ's reasoning, particularly post 9/11, hasn't been the best. It would be good if the ICJ had responded to the practice. And I think I've said this all along, that ultimately what really matters for the judicial decisions of the ICJ what really matters, or what should really matter, is how well they're reasoned. And so in this instance, if they're not well reasoned, then the question is, what now? I think, though, here's the saving grace for the ICJ decisions. So the first saving grace for the ICJ decisions is, I think Nicaragua was well reasoned. And Nicaragua, I mean, those words that you quoted, I don't have them here, but those words that you quoted, the court didn't thumbsuck those words. Those words came from the GA resolution defining aggression. So that's where it comes from. It didn't thumbsuck it. The other cases, including the Wall opinion, refer to Nicaragua. So I think in that sense, the court, I guess, might be saying, hey, we've said this before, we've reasoned this before, we don't have to reason it again. All that we're doing now is we're telling you what the view of the court has been. So the court says, the court had said, or the court has said, or as the court said in, so that's a saving grace. But it's not the main saving grace. For me, the main saving grace for the jurisprudence of the court is that, save for interested states, in other words, those states that in a particular case have an interest in undermining the jurisprudence of the court, states haven't rejected Nicaragua, right? There are debates in the General Assembly often about these things. States haven't. Now, I will give you this, that in this last debate that Chantel referred to, and you also spoke about under the presidency of Mexico, I think it was in February, there were some states that sort of referred not in a positive way to Nicaragua, but generally states haven't undermined so the jurisprudence of the ICJ. And why that's important from a methodological perspective, because at least we agree on methodology, is if we agree that ultimately what we're interested in is we're interested in the position of states, if there is this long-standing jurisprudence, and there's a very clear intent to at least from some quarters to undermine it, you would expect that many states would sort of join the bandwagon, and states haven't generally joined the bandwagon. And I think that's a saving grace that accepts that suggests to me an acceptance of the Nicaragua jurisprudence. Final point on this, you are right that there are different ways that one could read the Wall opinion, and there are different ways that one could read that one could read the armed activities in the territories of the Congo. But I think to do that would be to ignore the fact that the court is aware that there has been criticism from some quarters of its jurisprudence. And so if the court wanted to make a shift, the nuances that you and other authors speak about, the court would do so explicitly because there is this general discussion about this issue. So that's the first point about that. The second point about that is that many of the separate and dissenting opinions, of course, criticize the court. So let's not forget that there is judicial dialogue between the judges on the court about this, and very often the fact that dissenting opinions and separate opinions, very often, not always, are critical of the court is an indication that those voices were not able to shape. Particularly if you read the dissenting opinion of Zimmer, for example, it doesn't say the court didn't address this issue. It criticizes the court for adopting a position, right? So for sticking with its Nicaragua. So it seems to be suggesting that in the deliberations between the judges, so the majority said, no, Nicaragua still stands. So I think that even though you're right, that it could have been better reasoned, the court could have engaged with the new practice. The court could have engaged with Resolution 1368 and 1373. The fact of the matter is that the court felt it's sufficient just simply to refer to its previous decisions. And until such time that states overwhelmingly reject it, then I think the court is within reason to do that.
Thank you very much, Dire. Now, I've been monitoring the comments, and essentially many of the comments are high-fiving the quality of the discussion. There were some comments earlier that picked up on some of the issues that were touched on. And I gather that there is a very significant contingent from the University of the West Indies Mona campus that have been engaging on this discussion. So it's very good to see that particularly students have been following this interesting discussion. And it shows that international law is a living, breathing instrument. You know, it's something that isn't really, you know, it's not abstract. It literally is developed through the actions of states. And we've been engaging very meaningfully throughout the last hour plus on essentially, you know, how states have been through their practice, through you know, engaging on this important issue through debates. We've touched on debates recently taking place in the Security Council on this issue. And before I sum up, I wanted to know if Kamille and Dire, if there were any lasting thoughts. You've been so generous with your time in sharing so many of your perspectives on this issue, but I don't know if there are any lasting thoughts that you wanted to, you know, to provide at this stage on this very engaging subject.
Let me go first, and this time allow.
Okay, yes.
You want Kamille to have the last
final word.
So you want Kamille to have the last word?
Yes, I want Kamille to have the final word this time.
Very fitting. Yes.
Yeah, it's always unfair when, I think it's always unfair on her that I always have the last word. So actually, I don't want to say anything substantive. I really just want to say that I thought this was a really interesting discussion. I thought that, Kamille, you've obviously done a lot of work. You're very knowledgeable in the subject, and you could see I was getting very excited. I don't always get excited. It has to do with how you presented the argument. So really, thank you very much for this very engaging discussion. I think it is an important subject. It's an extremely important subject, and it's not just theoretical. People should think about the policy implications of entitling states to use force against non-state actors in the territory of third states where there's no attribution. What does that mean? My policy perspective, my policy point of departure is always one that's focused on power relations. I know for a fact that a small country in my region is not going to use force against non-state actors in my country, but I know that possibly my own country has the ability to use force against non-state actors in the territory of a third state. There's a reason why the charter says what it says. The purpose of these charter provisions are, to quote from the preamble, save succeeding generations from the scourge of war. And by opening up this possibility of using force against non-state actors where the third state, the territorial state, has done absolutely nothing wrong, we are creating the possibility of throwing succeeding generations into the scourge of war yet again. Those will be my final words.
Yeah, and I mean, what do you say after that, though? But I'll just say that when Chantal asked me about presenting and about who would be a good person to engage with, right away Dire came to mind. And that's because I knew that we didn't see eye to eye on aspects of this, but I do agree with you wholeheartedly that the international community more generally needs to think about the implications here. And I think the theme that ran throughout the recent debate in the Security Council was how much states have said nothing and how much states need to participate in shaping the law that could potentially affect them. And I think that's particularly important for small states, like you said, for small states in the Caribbean that hardly participated in a debate that passed, even though it was one that was open to all states to participating. So, while I do argue for, based, objectively on what has been observed in the practice and opinion use of states, that this right does exist, I think there are aspects of it that are still very much unsettled, like the unwilling, unable test, like you mentioned earlier, which I think a whole debate can be had on. And there are lots of other aspects of how this right is regulated that is still left to be resolved. And so states need to be other than silent. They need to be other than quiet in this area of the law. So that would be my final word.
Well, I don't want to burst anyone's bubble, but I think you may have to have another word because there is a question that came from Gabrielle Elliott Williams that I'd like you to address. Gabrielle, as I understand it, wants you to go back to Dire's invocation of the practice of members of the non-aligned movement and to see what your response or thoughts on that particular issue would be.
Right. So the non-aligned movement, as Dire mentioned, is a substantial grouping of states. And what the non-aligned movement has done, whenever it has its conferences, it stipulates its principled position on the use of force, the rules governing the use of force, self-defense, and other rules. And what the non-aligned movement has said in its most recent statement and in the statements that preceded that is that the rules on the use of force ought to be interpreted as restrictive and ought not to be reinterpreted. And many have taken that to be an indication that the non-aligned movement is rejecting a right of self-defense against non-state actors. But in my own assessment of what the non-aligned movement has said, those statements weren't addressed specifically to the question of non-state actor self-defense, but were, as I said, a general principled statement of their position on the rules governing the use of force. And I think that ought to be contrasted with what they've said about preemptive use of force and about unilateral humanitarian intervention, where they've explicitly said, we do not accept that there is a right of unilateral humanitarian intervention. We do not accept that states enjoy a right to use force preemptively against attacks that are not imminent. So those things have been specifically and expressly communicated in NAM statements, whereas there hasn't been this rejection of a right of self-defense against non-state actors. And I think we also need to take that statement in the context of what NAM states have actually done. So there are a number of NAM states that have invoked a right of self-defense against non-state actors. So I think if we read that statement in that context of their actual actions and against what they've said against, rejecting other expansions of the rules on the use of force, then we need not read the statement as rejecting a right of self-defense against non-state actors. That's what I'd say on that specifically. Thank you so much for that question, Gabrielle Elliott Williams.
Dire, you wanted to come in before we wrap up? Yeah.
Trying to find the text, but I think the 2017 text, of the non-aligned movement does refer to terrorism. It does refer to the it refers to a trend. I think the trend of states using Article 51 to respond to terrorism. I know this even though I'm not looking at it because I was involved in the negotiating of that language. And I know that even though it doesn't say so, it's directed specifically at the Syria situation. And I don't know what else has come after that, but at least at one time I know there was a specific reference to terrorism in that context.
Yes, and I think that is right, that there was an expression of a concern of the invocation of Article 51 in that context. But again, I think a concern is not necessarily a rejection of a right of self-defense in the context.
I would have been so surprised if we did not end on this engaging note. I would have been extremely surprised. I just have to thank, so generously, both Kamille and Dire for accepting the invitation of the branch to participate in this dialogue. We believe it's so important for these kinds of engaging discussions on international law to involve, international lawyers who are, emerging, as well as established international lawyers. And that's exactly what we had in this dialogue. And it was just so enriching to see this and this discussion, the clarity with which both of you put forward your perspectives. I think it was engaging not just for people who are new to the subject, but also engaging for people who are fully steeped in the subject. And I thank you so much for giving so generously of your time. Dire, we're very conscious that it's, I think, approaching 8 p.m. in South Africa right now. Or it's approaching 9 p.m.?
7.
Okay.
Dinner time.
So, dinner time. So thank you so much for giving of your time. And again, thank you so much to all our viewers who tuned in. Of course, this discussion is going to be on the branch's YouTube channel. So even if persons weren't able to log on right now, they'll be able to view it later. But thank you so much for our viewers who logged on and showed their appreciation for the discussion with their very helpful comments. And so we just like to again thank both of our speakers, thank our viewers, and we look forward to having future events where we all engage on this important subject called international law in its variants. Thank you so much, everyone. Take good care.